Good morning, everyone. Thank you for joining us. My name is Taylor Evans. I am an attorney here at Maynard Worth, and you're here today because you're curious about slipping and tripping on business premises.
And I'm James Urrutia. I'm also an attorney here at Maynard Worth. We appreciate the time you're spending to be with us, and we're excited to talk to you about this topic that has become real prevalent in our community, especially with all the hotels. And during the pandemic, the only places we're going is into stores, and so we're seeing a lot more of these incidents occurring.
Yeah, absolutely. It was important for us to do this webinar so that you guys have the information you need should you find yourself in this situation, and hopefully you don't.
If you ever have any questions as we're going through it, feel free. We're paying attention to the chat box, and we'll always be able to stop and talk about any question you have. Or if you want to go back to a slide, feel free to jump in at any time. Let's get going. First off, what we're going to talk about today is number one, some of the types of slip and falls there are, the challenges that arise legally and with the evidentiary issues that arise in our cases with slip and falls or trip and falls. We're talking about preserving the evidence so that we can overcome those challenges, and how you and your family members can preserve that evidence to strengthen your case as time goes on. We're going to talk about what happens even if you don't actually hit the ground, what you should do, and talk about medical treatment. And just the main question we get a lot from most of our clients is,
Definitely.
how much is the case worth? So we're going to kind of go through there. We're going to spend most of our time in the challenges and the preservation of evidence, and because those are kind of the two most important parts of these types of cases.
So there are lots of different variations of falling or tripping at a business premises. And so we think kind of the most common ones we see are actually slipping on some sort of liquid that's on the ground. Maybe, there was an employee who didn't sweep that area in a timely manner, or maybe someone just actually dropped something, some sort of liquid substance, and employee didn't have time to come through and clean it up. Another really common thing that we see in high traffic areas, for example, that grocery stores, if they're falling on some sort of fruit in the produce section, that's another area that we see that are pretty common for slip and fall cases.
Definitely. We have cases in apartment complexes due to water damage and roofs falling. We have slip and falls in apartment complexes. We have, people falling off ladders in other people's houses.
Yeah, I have one where the client was on a premises and they sat in a chair and the chair just collapsed. And so that's a fun little twist one where it's like a products liability issue, which James is great at, and then also the actual premise liability, and sort of falls in that slip and fall case. And it looks like we have our first question. Chelsea says, if you fall off a ladder at another person's house, is it my fault or theirs? Really good question. Really good question, Chelsea. You want to go and let me take that?
I'll let Taylor do that one.
Yeah, I have unfortunately, a lot of questions that come to mind. And in fact, I would need a little bit more information. But I'll tell you, it's not uncommon for you or anyone to be visiting a friend's house or even a family member's house and be injured while all on their property. I think the most important thing in that respect would be, to hopefully your friend has homeowners insurance, and that we can get that information from your friend or family member. But I don't think it's your fault if you've fallen off a ladder. Hopefully you're not doing anything like dancing up there or anything in that respect. If you're on the ladder and you're, using it as it is intended to be used, and you fall, then I can't say that would be your fault at all.
Yeah, and of course, every scenario will depend on all the specific facts.
Mm-hmm.
And partly why we're talking about the different types is to help you understand that really what we're going to be talking about applies basically anytime you or someone is injured or hurt while you're literally on the premises of somebody else's property. And there's so many ways people get hurt on properties that they do not own and somebody else owns it. And the law that we're going to talk about, the preservation of evidence we're going to talk about, that applies in all of those situations. So some of the challenges of slip and fall, number one is just the law in Nevada. Taylor's also licensed in California. I'm licensed in Utah. And what we're, however, talking specifically about is the law in Nevada. And it's a real challenge. It's an uphill battle because there are Nevada Supreme Court cases that say, and you read this first one, is just because you were injured on somebody's property doesn't necessarily mean you have a right to recover money from that person.
And a lot of times we find that's really counterintuitive. It's really challenging for our clients to understand that. Hey, if you're walking and through no fault of your own, you slipped on a liquid, then that person should compensate you for that. For whatever injuries that resulted because of that. And that's simply not the law. The challenge is on you, the injured party, and us as your attorneys, if we're representing you, to prove why the liquid was there, how long the liquid was there.
Yeah, and that goes to notice.
Mm-hmm.
You have to prove that it was a hazard, whatever you tripped on, and that the business owner or the property owner knew that that was a hazard. Mm-hmm. And so there's a lot of issues with that, especially when we're talking about most of the time, most of our cases are temporary hazards, meaning water that's only temporarily on the ground for some period of time before a client or a person gets hurt, or a grape temporarily on the ground. And so when we're talking about temporary hazard, that's called constructive notice, and it's a challenging aspect of the law in Nevada that you and we as the attorneys have to overcome to even get your case in front of a jury.
And that makes it really quite different than a normal car accident case where you know the person that hit you, where you get out and assess the damage, you exchange information, and that isn't the case when you are injured on a business premises.
And all of these challenges, as we'll talk about later, also go towards the value of your case. Mm-hmm. When we just objectively look at the challenges we all have to overcome to win one of these cases, it directly affects the value of the case. And so if we'll move on down to how we can overcome some of these challenges by preserving the evidence.
And so it's crucial that if you ever find yourself in this situation, and I'll step back a minute and say that a lot of times our natural reaction when we fall at any point is embarrassment. Oh my goodness, did anyone see me?
Well, we hear that from all of our clients.
All of our clients. I can't believe that just happened. They just want to beeline for the door really as soon as it happens. And so it's important that once you can kind of overcome those feelings, that you go into a sort of a fight or flight mode and you gather as much information and evidence as possible, because the business is the one in a situation like this that really almost holds all of the cards, essentially, because they hold the evidence.
Well, and to jump to the fight or flight, so many clients, and I can think of multiple examples, where after they fall, that their initial reaction with that embarrassment is to leave. You just want to get out of there, and you don't want to have people see you. You don't want people to see you wet. You don't want people to see you hurt. And so people, it's just a natural instinct to get out of the store. But what we really want to highlight is that is the exact opposite reaction you need to have in these situations, because of how the evidence that you gather in the moment, you or a friend or another customer or somebody, you got to find a way to gather that evidence, because the store is not going to do it for you.
Absolutely. And so, if you're able to gather yourself, and luckily, hopefully there's no broken bones or anything that requires, immediate medical attention, then you're going to want to stop and you're going to want to assess the area around you. You're going to want to take photos. You're going to want to take videos. If someone comes up to you, if another patron's in the store and they say, oh my goodness, I saw what happened, ask that person for their information, get their name, get their contact information, because that person is a witness. And they can really, really be a key witness and add value to your case later down the line.
Well, and that makes me think of a case right now I'm working on where our client slipped and fell in a puddle of water, and she couldn't get up. There was such a big puddle, she kept slipping, and another customer that was standing there had to help her get up. Well, unfortunately for her and us, nobody got that customer's name, this guy's name, didn't get his contact info. And he would be someone, and especially we have the video evidence, that would be so important for her case, that if we had his information, had his testimony, had his side of the story, our case would be a lot stronger and it would increase the value of the case.
Right. And so, again, just important to really get as much information as possible. You're going to take photos of the area, take photos of the substance that you slipped on. As James said earlier, sometimes in these situations, it's a temporary hazard. The water can be cleaned up, or detergent can be cleaned up. Take a picture of it right when you kind of get up and you're able to collect yourself, and also record video evidence if you can.
Well, one of the biggest points, if we can, if you're going to remember one thing from this aspect of this presentation, I hope you remember this. You cannot leave the store without knowing what you slipped on or what caused your injury. You cannot leave unless you know that. Because when you get asked later by the insurance company, by a defense attorney, imagine MGM's attorney taking your deposition, interviewing you under oath, and they're going to ask you, what did you fall on? What did you slip on? And if your answer to that question is, I don't know, your case is done. You cannot leave the store until you know what you slipped on.
And so some other important things to remember, that you're trying to collect evidence, you're in that fight or flight mode. You're going to want to, when you speak to the employees or the manager of the store, they're going to ask you for a written statement, typically part of their policy. Ask them for a copy of that statement. If they don't give you a copy of the statement, take a picture of the statement so that you can see for yourself, without them saying later down the line, perhaps maybe they lost it or something of that nature, because we've had those situations.
Well, and to that point, and this goes back to, if you have your cell phone with you, you should really just leave it video recording everything you do after the fact, to help get names of these employees. You shouldn't leave the store without having a couple names of employees that you talk to, customer names. All of this information is vital to winning your case in the future.
Oh, David has another question for us. I'll let you take this one, James.
If I slip and fall at a business and I feel like I can't get up, should I still try to get up, or should I just lay there? Thanks for your question, David. It doesn't matter too much what you do. You don't want to. One of the worst things our clients do is exaggerate their injuries, and you definitely don't want to exaggerate your injuries. If you feel you can get up medically, physically, then you get up. If you don't feel like you can, or you're not sure if you can, you feel severe pain in your neck or your back. Obviously, I'm not a doctor, but there's going to be times where you can't get up because you dislocated your knee, or you tore an ACL. So there's no advice there. That's just your preference. But one of the things is that they should be helping you right away. So employees of the store, the business, they should be helping you. They should be getting you a chair. They should be checking on you. They should be calling.
And they're going to ask you too if you feel like you need medical attention, and if you genuinely feel like you can't get up, David, then tell them you do need medical attention, and then it's on the store to call 911 and the proper authorities to come and get you checked out. Certainly. And so one other thing I want to touch on before we go to the next slide is that so important to save your clothes and your shoes. I know a lot of times, and I'm laughing at it because so many clients tell me, oh, I cleaned my shoe. Oh, I washed the clothes. I had a huge puddle. I was wet all on the side of me. All of that is evidence. It's evidence that'll help your case later down the line. So don't clean your shoes. Don't wash your clothes. And in fact, when you do give us a call and meet with us, bring those items with you, and we'll preserve them in our evidence locker.
And it's a great point. I mean, if your clothes are wet, just imagine that is, again, that's temporary evidence. You need to take pictures of that those wet clothes or the dirty or, whatever it is. You need to at least at a minimum take pictures of it, save the item. One of the things we hear from our clients a lot is, and the reason why they're not worried about saving all this evidence after the incident happens is because we hear this all the time.
Assume.
They have videos. I know they have cameras. It's going to all be on video. That is not the case. You got to get that out of your head. And let me give you an example here on the next slide. Here's the type of quality of video you will get.
I mean, it's 2020. What are these cameras? These are terrible.
And this is a screenshot from real surveillance footage. This is not going to help you win your case.
No, it's bad. It's bad. And in fact, I've had situations where the business told us that my client was never in the store that day. They tried to tell us that, I guess she made up everything up in her head. And it wasn't until years down the line where we filed the lawsuit and we got the information through the discovery process that they gave us the video. Suddenly they found her. And lo and behold, it was the exact date, the exact time that she said she was in the store. So if you have all that video evidence yourself, it's really going to be helpful throughout the entirety of your case.
So this slide is a picture. It's just a picture. We're not going to watch the video. But if you can all look at this picture, that's our client. Her case is resolved. This is in a hotel, a major shopping area of a hotel. And in 2 more steps, she's going to slip and fall and tear ligaments in her knee. And I want you to look at that right in front of her on the white. Can anyone tell us what she slipped on? No. And luckily in this case, an employee noted that there was coffee on the ground. Well, if the employee hadn't notated that, our client left the scene not knowing. I mean, she was severely injured, so it's understandable. But she left the scene not knowing what she slipped on. And in part, she told us because she figured the casino would have video that would prove what she slipped on. Well, this is the video we got. And literally in 2 steps, she's going to slip and fall right there. We don't know. From this video, you cannot tell. So again, this is highlighting the point of you cannot rely on surveillance and you cannot leave the scene without knowing what you slipped on. And unfortunately for her, an employee didn't lie in this case and admitted that there was some coffee on the ground there that they hadn't cleaned up. Looks like we've got a question.
We got a couple questions coming in. Hi, Elise. Elise says, if I fell at Walmart and my back hurt and I wasn't able to go into work the next day, how much would Walmart give me? Oh, that's a good question, Elise. And it's actually a common question. I'm sure you're not the only one that's joined us here that wants to know how much the case is worth. And we're going to touch on this a little bit later, but I have to give you the answer I give all my clients, and I'm so sorry, but it depends. These cases are so fact specific, where you fell, what you fell on, what evidence we can gather. I think in that situation, if this was recent, at least I'm not sure if it happened recently, but since your back is hurting, you can't go to work, definitely go get checked out and go see a doctor and seek medical attention.
Well, and just from a Walmart standpoint, that defendant in general is amazing at hiding and destroying evidence. And it all depends. Again, going back to the challenges is, okay, what did you slip on? Do you know what you slipped on? How long was it there? And then when we start talking about more value is what are your injuries? And that's, what it comes down to. But again, you cannot leave a Walmart without knowing every detail of what happened. Otherwise, that evidence is likely going to be gone.
Chelsea here. Thanks for your question, Chelsea. Because what if you don't know what the liquid is? Does it hurt your case if you guess the liquid? What do you do in that situation?
Yeah, thank you for that question. I mean, my first thought on that is you have to be able to, at a minimum, describe the liquid with as much specifics as you can. The size of it, the feeling of it, the smell of it, whether it's sticky or not, the color of it. The more ways you can describe the liquid, the more likely it is that we can overcome some of the legal fights that we'll have in the future.
All right, next up we got Lisa. Am I allowed to legally take photos of the scene that I fell at a business? Yes, you can take photos of the immediate vicinity. And this is a really great question because a lot of times, when you're under a different circumstance, if you're in a store and you're just snapping photos of everything, you may get a little visit from security or a manager say, hey, stop taking pictures. But this is different. This is a situation where you are permitted to take photos of the immediate area and ask for the employee and manager's information. I can tell you 9 times out of 10, they may not want to provide their full name. That's okay. Just get their first name and their title. And that way we know specifically, when we're actually going to file the lawsuit, John was the manager on duty that day. And that helps us moving forward on your case.
Well, and sometimes if you're, hurt so badly that you're being transported directly to a hospital, you're really going to have to rely on friends and family to get over to that store as soon as possible, or an attorney to get over to the store so that there can be pictures taken that day, ideally that day or within a couple, 72 hours, so that the scene can be well documented, and just in case the store is not going to document the scene, which we know happens basically in every case. So, yeah, you can take pictures. The store, they're open to the public. You're allowed to walk in there. Anybody could walk in there. You're allowed to take pictures. Now, if security kicks you out at some point, you got to leave. But no, you're definitely allowed to do that. Thank you for your question.
With that, I think we're ready for our next slide here.
Do we have another question down there? So.
Oh, did I miss a question? I'm sorry. Rose, what if I fall at someone's house and they don't have insurance? Can I still sue? Oh, you can. That is the short answer there. You can still sue. It's more difficult when someone doesn't have insurance. In most cases, everyone carries insurance because they don't necessarily have personal assets, other than maybe their home or their car. So insurance is that extra layer of protection that's going to protect your personal assets. So if you fall at someone's house and they don't have insurance, that layer is gone away, and you can potentially collect on their personal assets. But the problem is, especially in this day and age with our, COVID and economy, not everyone has assets. And so that's just kind of the practical side of, if you're suing them, are they really going to be able to compensate you for your injury?
Well, and my thought on that is, we here at Maynard Wirth, one of our expertise really is recovering money from insurance companies. And it really, there's a lot of challenges that get presented from trying to sue someone that doesn't have insurance. Yeah, at the end of the day, even if you won a jury trial or a trial, you could have a piece of paper that says this person owes you, whatever it is, $10 million, but you're never going to be able, if you're never be able to collect any portion of that 10 million, they're really worth all the time, money, energy, emotional stress to go through that process. And the answer to that question 99% of the time is no. This is this slide that we just wanted to show you. This is an example of a witness statement. So before you leave a business, they should be providing you a form similar to this, where you can write your statement of what happened. And this statement is it becomes a very important document in a lawsuit. And again, that's why before you write this statement, you should know what you slipped on, what injured you, what you tripped on, and you should be able to describe it specifically in a document like this on that
If
day.
anyone came and told you they witnessed it, that person's information could also be on here.
Employee names, witness names.
Absolutely, absolutely. And again, this is something that you want to request a copy of for your records. If they won't allow that, just take a picture of it and save it yourself. So what happens if you slipped or tripped, but you didn't fall? And so oh, do we have some more questions? Oh, okay. Let's see. I got Joey. Hi, Joey. He says, what if there is a warning sign, but I still slip on a wet floor? Do I still have a slip and fall claim? I got a little pop-up here. Let me clear it out the way.
I'll jump on that one real quick.
Yeah.
Yes, you do. And actually, sometimes it's a better case because the fact that they put a sign up shows that they know, they have actual knowledge, and that's a legal phrase, actual knowledge, that there was a hazard on the ground. And so if you end up slipping on that hazard, even though there's a caution sign, there's still a chance of recovery legally. You know, there's going to be issues, and again, from a value standpoint, and we haven't talked about this yet, and we should have, as one of the challenges, is that every slip and fall case that goes to trial, a jury is going to blame the person who slipped some amount, whether it's 5% or 100%. The person who slips is going to be blamed for it.
And that part of the reason of that is we have a duty. Everyone, each one of us has a duty to pay attention where we're going. And so that's why a lot of times when you do get to a trial down the line, the jury knows that they're given instructions. They say under the law, you have a duty to pay attention, for lack of a better phrase, to pay attention to where you're going. So there's a little bit of onus and accountability that can fall on you, you know, for not having seen. But a lot of times, and it's a human factor situation where we're in a grocery store, for example, we're looking at the shelves, we're shopping, we're not, you know, looking at every step in front of us. That's completely natural. No one walks in his door and does that. That's a little strange. But getting back to Joey's question, you absolutely do still have a claim, even if there was a warning sign around it.
I see another question from Lisa. What if you fall at a family member's home and I don't want to sue them? What should I do? I mean, my initial thought on that is hopefully you have health insurance and you can get the medical treatment you need under health insurance, and not have to sue them. The other thing, and again, you should always consult with, you know, attorneys on this issue, is because sometimes we can come up with other theories that would allow us to sue some other entity, some other business, depending on the situation, besides the owner of the home or the owner of the property. So there's a lot of situations where we can, you know, sue somebody else besides the owner of the property.
And getting back to the slide, if you don't actually fall completely down if after you've slipped or you've tripped, that's okay. You know, you may still have a claim. It's just important, again, that you just give us a call and we'll talk to you about it and we'll walk you through and give you our honest opinion.
And Lisa, again, I see your question. No, I mean, it depends on what you mean by effect, I guess. If, you know, as long as they're not named in the lawsuit, then they should be fine. You know, they're still kind of a witness. They might still have to participate in some way, but it shouldn't affect their insurance, shouldn't affect them really. So.
Yeah. What is most important, as James, you kind of already alluded to, was going to get that medical treatment. And if you're feeling in any sort of way, you know, hey, I feel off, sometimes it can take a couple days before you really start feeling the effects of your injuries. It's so important that you do seek medical treatment, and hopefully you do have health insurance so that it's not an outstanding or rather large cost to you personally.
Well, you just have to remember, juries and insurance companies do not believe people are hurt unless they've been to a doctor.
That's true.
So if you're feeling any type of pain, soreness, discomfort of any kind, you really need to get in and have a medical professional document that. Otherwise, your word in these cases hold very little weight as to your physical state, unless you're telling it, unless a medical professional is documenting it.
Yeah. I see we're running close on our time here. We had so many great questions. Please reach out to us. We have our contact information in the slide. We have a great app you can reach us at, Injury Assist for Maynard Worth. And we are here anytime you want to give us a call. Please do. It's important, if you can, remember to give us a call as soon as possible. Thanks for joining us.
Hey, do we want to, are there any more questions? I don't know if we need to get off right away. Are there any more questions?
Oh, we can still, oh yeah, let's go.
Let's make sure.
Oh, we got.
I don't know. I heard somebody. What if I felt okay after a fall, but started to experience symptoms later? Should I go back and try to collect evidence? Yes.
Yeah.
Yes,
Sure.
and you should be getting into a doctor, you should be getting into a medical professional right away. You should go back. You should, you need to let them know, and you need to let the store know and create an incident report. I have a case right now where our client, she tried to do an incident report on the day of the incident. She was so embarrassed, she didn't want to go back in the store that same day. And she tried to do it over the phone, couldn't get around to anyone. 2 days later, went back. So yes, yeah, the most important part is you just document it as soon as you can.
Absolutely.
We're being told we can go as long as we need. So if there's any other questions, I guess you want to touch on the case value real fast. We kind of did.
Oh, sure. Yeah, a little bit. Elise had a great question earlier about how much her case would be worth if her back was hurting after falling at Walmart. And we did kind of touch on this about how it's really pretty fact specific, and we don't have, an exact answer or dollar amount number for what the case would be valued at.
Well, and so most of the value of any case is determined on two things: liability, who's at fault, and how, are they at fault, and how much they're at fault, and what are your damages, your injuries caused by that fault of the other person. And so those are two big factors that when we are analyzing the value of a case, we're putting percentages, number one, on the liability. So we got to put a percentage on it. And then based on our experience of jury trials, mediations, arbitration awards, settlements over the many years that we've been doing this, we're able to put a dollar value on the medical treatment you've received, the injuries you've received, the pain and suffering you've experienced, and just the overall losses and damages you've suffered. And so we're able to do that, and then we analyze the liability, and we then look at the range of outcomes that can occur at trial, right? So, hey, we have this percentage of winning your case, and here's your damages. And so we're able to kind of analyze that as a group. We have 7 attorneys here that are experienced in doing this, and we're always roundtabling each case to come up with what we believe is a objective range of value for a case. And so again, on a slip and fall case, trip and fall case, so much depends on, well, what evidence do we have for the liability? That, that's a big aspect of the case, because if our chances of winning a slip and fall case is only 20%, right, the value of your case is drastically affected to the downside. If we feel that we have enough evidence to win a slip and fall case at an 80% clip, right, if we go to trial 100 times, we'll win 80 of them, then that pushes the value of your case upwards. And again, it goes back to the legal challenges and the evidentiary challenges. I don't know if you want.
And also on that point, the value of your case can change over time. And it can change a couple different ways. It can change with the medical treatment and that you've received and the amount of doctor's visits. It can change with the duration of your pain and suffering. How has your life been impacted after this injury? And it can also change when we get into the discovery period and we get some investigation and we find out more information and perhaps even more wrongdoing on the part of the business. So it can, how much your case is worth could be different at the very beginning versus in the middle versus at the end of the case. I think Rose has a question for us.
before we jump to that question, one thought I had was, and that's one of the things we're good at, is leveraging those kind of pressure points to increase value of cases. And there's a lot of legal ways and that we kind of know that will add pressure and add leverage to the Walmarts of the world, to the MGMs of the world, those businesses that want to hide evidence, et cetera. And so it's on us to do our best to leverage those pressure points, try to add value to cases as much as we can.
Yeah, so Rose's question is, do you have your own app? It looks like it on the picture. Yes. Yes, we do. We have Injury Assist is the name of the app. You can go to your app store, whether you have iPhone or Google Play, and you can download it. Oh. Yeah, Injury Assist. Thank you. But I should have spelled it for you. But we have David. On average, how much money should I accept in a slip and fall case?
I need a lot of details. I need to know what your evidence is. I need to know what your medical treatment is. There really is no average, except I can tell you the average settlement of a slip and fall case is going to be substantially lower than the average value of a rear end case. That's about the most definitive things we can say. So if your rear end case with similar injuries netted, got you X amount of dollars 5 years ago, your slip and fall case with the same amount of injuries is going to get you X amount of dollars times 50% or half of that. Your slip and fall case is less valuable than your rear end case.
Yeah, at least initially. Again, these cases are difficult because we're dealing with businesses that have all the evidence. And so it's important that you gather that information as soon as possible, and then you contact hopefully our office so that we can, if we need to, even send someone out. We've done that before where we send someone to the store and they've been able to get more information as well for you.
Including experts. I mean, we'll send experts out as soon as we can to do testing, to document. Sometimes they let us, sometimes they don't. But we'll even before we file a lawsuit, depending on the case, we'll try to get experts out there to the scene.
Oh, David has another. David, you need to give us a call, man. But no problem. Let's see. Would my prior injury from a different case affect a new case? That's really good. That's a good question. You got some good questions. So first thing, you need to be 100% upfront with your attorney. A lot of times, too often, we have clients who want to hide the fact that they've been in prior accidents or slip and falls or trip and falls. And we need to know as much information as possible upfront so that we know how to potentially overcome any issues that may relate to a prior accident or injury. It will affect your new case. The long and short of it is it will affect it. So we need to be able to obtain those records related to your prior injury. So as soon as you can get us that information, we'd order those records, we'd assess it, and we would move forward from there. Yeah.
Well, and luckily there's some really good law in Nevada on this topic that's in the favor of the plaintiff or the injured person. Yeah. But really, when it comes down, the main question is, had your injuries from the prior incident, the prior case, had your injuries from that incident resolved prior to your new incident, or were you still feeling the effects of those prior injuries when the new incident happened? And that is the first big question. If you tell us, hey, I had prior injuries, but I wasn't on the day that the new incident happened, I was fine. I was 99%, I was back to normal. That's one thing. If you tell us you were still in pain and then you have a new incident, then what happens is it's about the change in pain. So if you're on the day of the incident, if your pain was a 2, and then because of the incident, now your pain is a 9, and it stays above a 2 for however long, then that's all, you're able to get compensated for all of that increase in pain until your pain level goes back to where it was prior to the new incident.
Yeah. So please give us a call. We'll talk about the case with you, whether or not you have a potential claim. But it's important that you reach out and seek counsel as soon as possible. And so we have our Injury Assist app that you can contact us at. We have our website, mainerworth.com. Our phone number, 702-464-5000. David, call us. You got some pretty specific questions, man.
And then our office, we have only one office location right now in Las Vegas. And we're down here in the Southwest, Fort Apache and Russell area. And so you can also just come in anytime. We don't require an appointment for you to come in. We love seeing our clients and potential new clients. So feel free to come in. There will always be an attorney or a staff member willing to talk to you and answer any questions you have. Any other questions before we get off, I guess?
So far, no? All right. Well, thank you so much for joining us for Slipping and Tripping on Business Premises. Please, again, give us a call if you have any questions. Bye, guys.
Thank you.